Good evening. I'm Jeffrey Old, the presidential candidate of the Citizens Party. Today I will be talking about the First Amendment, specifically the freedom of speech and the role of the Supreme Court in defining it. While there are many aspects of freedom of speech, I will focus on these main points. First, I will discuss the origins of freedom of speech. Second, I will discuss some limits on free speech, including court decisions and laws. Third, I will discuss protections of free speech. Finally, I will tell you some of my thoughts on freedom of speech and the role of the court in defining it. But before I start, I would like to thank everyone for attending the speech. The freedom of speech finds its roots in the First Amendment. This First Amendment, in turn, finds its roots in the Bill of Rights, the first 10 amendments. The text of the freedom of speech clause of the First Amendment is only a few words. Congress shall make no law abridging the freedom of speech or the press. You may notice that the freedom of press is also included. When the Bill of Rights was introduced, press only referred to newspapers. Now, press includes all forms of information distribution. Even though the text of the freedom of speech clause is only a few words, it has been the subject of numerous developments and Supreme Court cases since its inception. I now will discuss the limit on free speech known as prior restraint, which is a form of censorship that allows the U.S. government to stop an idea from being published or said before it reaches the public. Because of the importance of free speech, the U.S. Supreme Court allows the use of prior restraint in only a few situations. In Greer v. Spock, the court decided that political literature can be prohibited on military bases if the literature is not approved by military authorities. The second permissible use of prior restraint came out of the Supreme Court case Snepp v. United States, 1980, in which the court decided that a CIA agent cannot publish anything about the agency without the permission of the CIA. The third situation in which prior restraint is permitted came out of the Supreme Court case Thornburg v. Abbott, 1989. This case upheld the constitutionality of a federal prison rule that allows officials to prevent an inmate from receiving publications considered detrimental to the security, good order, or discipline of the prison. The Supreme Court also has given the power of prior restraint to public school officials, allowing the censorship of any school-sponsored expressive activities. This came out of the Supreme Court case Hazelwood School District v. Kuhlmeyer. To recap, the idea of prior restraint is against the idea of free speech, so the Supreme Court only allows it in limited situations. The other limits on free speech are obscene material, seditious speech, limits placed by the FCC on the radio, network television, and finally the CIPA, a law that requires public libraries that receive federal money to use filters to block internet access to pornographic content. I hope to have an opportunity to talk more about these limits at another time. The Supreme Court has also upheld freedom of speech by protecting symbolic speech and commercial speech. In Texas v. Johnson, 1989, the Supreme Court ruled that burning an American flag is protected under the First Amendment because it is symbolic speech. That is, a form of speech that is expressed through conduct, not words. Commercial speech is for business purposes and usually refers to advertising. It was widely thought that commercial speech was not protected under the First Amendment until the 1975 case Bigelow v. Virginia, in which the Supreme Court held a Virginia state law unconstitutional because it prohibited the newspaper advertising of abortion services. The First Amendment does not protect false or misleading advertisements, nor advertisements for anything illegal. Now that you know a little more about free speech and the Supreme Court's role in defining it, I'll tell you what I plan to do with free speech if elected. In my opinion, freedom of speech should not be broadened, but neither should it be further limited. I do not mean that we should take freedom of speech for granted, because it is definitely one of the most important rights we as citizens have. If elected, I promise to make sure every U.S. citizen's freedom